Good morning. I hope you're all having a good day so far. This is the first lecture on equity and trusts, and we're starting with equity. Before we continue, it would be useful if you have the lecture notes that I've included onto Moodle on Introduction to Equity in front of you, because I will be using that as a guide. So what does equity mean? Well, to most people it means concepts such as fairness and justice, but in the law, in English law, it has a much narrower meaning. It's the body of rules originally developed and applied by the Court of Chancery. It is a source of law. Other sources of law include the common law as well as legislation, meaning acts of parliament. Moving on to the next slide, we're looking at how equity developed. It started with the common law. The common law being the law that was common to the land, which was enforced by the king at the time, the king's judges. Common law was developed through precedent. Precedent just means that judges followed previous judgments where the facts of the case were similar. And through precedents, it provided a strict body of law for the courts to follow. But where a party to a case that had come before the court that's been given judgment felt that the judge's decision was unfair, they had the option of appealing to the king directly. This was called throwing themselves upon the king's conscience. So the king, being inundated with too many applications, delegated it to his Lord Chancellor, whose office was known as the Chancery. And by the 15th century, the Chancery was actually recognized as a judicial body and called the Court of Chancery. To begin with, there were a lot of problems encountered by the Court of Chancery. Reason being the Chancellor was traditionally a member of the clergy with no formal legal training, not bound by precedent. So there was a saying at that time that equity could be measured by the length of the Chancellor's foot, because each succeeding Chancellor would provide a different judgment to cases which may seem similar. And because the Court of Chancery was using what we call concepts of fairness and justice to come to a decision in these sorts of situations, the law that was dispensed by the Court of Chancery became known as the law of equity, as we said, because it's based on the Chancellor's moral code. By the 17th century, the Earl of Nottingham, who was a lawyer, was appointed Lord Chancellor. And he started to set down principles upon which equity should operate. He came up with a framework. He basically tried to follow what common law judges had been doing all these years, ensured that records were kept of all proceedings, and this brought about precedents, as we know. He also developed equitable maxims and doctrines, which we're going to look at in the next lecture. Now, with this more ordered framework and precision, there were now two separate legal systems. There's the common law courts, which dealt with strict matters of law, and then there's the Court of Chancery, which dealt with equity. And as we said, anyone who wasn't happy with a judgment, obviously you had to start your proceedings in a court of law, in a common law court. And if you're unhappy with the results, then you can apply to the Court of Chancery. So two separate legal systems. And it was inevitable that there would come a time when there's a direct conflict between common law and equity. And this happened in the Earl of Oxford's case. Right. So in this case, a judgment was granted in a common law court, but it was alleged by the person who lost this case that it was obtained through fraud. So they appealed to the Court of Chancery, and the judge in the Court of Chancery, the Lord Chancellor at the time, Lord Ellesmere, in the Court of Chancery, agreed with the applicant that the judgment in the common law court was obtained by fraud. So he issued an injunction to prevent the plaintiff in the common law court case from enforcing the order. So to recap, common law court heard a case, found for the plaintiff, the claimant, as we know now, and ordered defendant to pay damages. Defendant wasn't happy, so defendant appealed to the Court of Chancery, claiming that the judgment in the common law court was obtained through fraud. The Lord Chancellor agreed with the defendant, i.e. the applicant, and so he granted an injunction to stop the plaintiff from collecting damages from the defendant. So direct conflict between the two. And this was then referred to the Attorney General at the time. And the Attorney General, looking at the case, the two cases, the common law court case as well as the appeal to the Court of Chancery, decided that he agreed with the Lord Chancellor, and so he upheld the injunction. And he also declared, and this was on the authority of the king at the time, I think it was James I, that in future, in any conflict between law and equity, equity shall prevail. This was set out in legislation. This was in the Judicature Acts 1873 to 75, which reiterated what the Attorney General said, that in the event of a conflict between law and equity, that equity was to prevail. And the Judicature Acts also set up a single court system. So what they did was to merge the common law courts with the Court of Equity, the Chancery Court, into one single court system. It was called the Supreme Court at the time, and it dealt with both law and equity together. The Supreme Court, as it was called at the time of the Judicature Acts, is now the High Court, which is, as you know, divided into three divisions: the Queen's Bench Division, the Chancery Division, and Family Division. And the High Court, as you know today, uses both common law and equity together. In your notes, you will see that I provided a bit extra, which is whether there's fusion of common law and equity or not. Now, today's lecture, this lecture is merely introduction. It's just so that you know what equity is and how it relates to the law. It's not examinable. You won't be examined on this. And neither is the issue on whether the common law and equity has fused or not, whether it's now a single law, single system, or whether they're running, whether equity and common law are running side by side. I've given you a sort of starting point. I've given you a few cases: Joseph against Lyons, Errington and Errington, and so on. But it's not something that, as I say, you will be examined on. It is, if in case you're interested to learn more, this is the starting point. That is it. Right. That's the end of Introduction to Equity.